Welcome, everyone. My name is Beata Leah. I'm a partner at the law firm of Minsky, McCormick, and Halligan. And with me is my associate, Chandni Shah. Chandni, why don't you introduce yourself?
Hi, everyone. As Beata said, I'm an associate here at Minsky, McCormick, and Halligan. I work primarily on employment-based cases, and specifically, a lot of my workload is in the H-1B field.
Right, so we're both at the law firm of Minsky, McCormick, and Halligan. We do exclusively U.S. immigration for corporate clients, individuals seeking to come to the United States, to remain in the United States, employers seeking to sponsor workers, all areas of U.S. immigration. And a large part of our practice is representing clients, corporate clients, and individuals through employment. And this is obviously a big topic of discussion right now, visa options for those individuals who are not selected in the H-1B lottery. So as anybody who is familiar with employment-based immigration, the H-1B visa is the most utilized visa for working in the United States for professionals. And every year, the USCIS conducts a lottery to determine who will get one of these new visas each year. And so the purpose of today's discussion is to go over options for individuals who were unfortunately not selected in this last lottery, which unfortunately is the vast majority of people. This was the most competitive lottery to date. And so it is obviously prudent for employers and these individuals to consider alternative options to working in the United States if they were not selected. The one thing to mention before we get started is that we are not going to have enough time to go over every single one of these options in great detail. We're going to just touch on these options briefly and then invite anybody who wants to speak to us afterwards about a specific case to set up a consultation with us. We do offer free consultations for corporate clients and organizations seeking to sponsor workers. If it's an individual themselves that is seeking assistance, that does incur a consultation fee, but employers are welcome to call us and schedule a free consultation for a second opinion or initial opinion regarding an employee. So please do utilize that resource.
Yeah, absolutely. I guess we can get started. As Beata stated, that there was a very low rate of individuals that were selected in the lottery, and that has been an increasing problem throughout the years. Beata, if you want to touch on the specifics of that.
Yeah, Congress created the H-1B visa in 1990 to allow employers to employ highly skilled, educated individuals in specialty occupations, so professional positions. And initially, they set a cap of 65,000 visas, and for a long time, that was deemed sufficient. Interestingly, Congress increased that number to 195,000 in 2001, and then decreased it again to 65,000 in 2004. In 2006, they added an additional 20,000 visas for individuals with U.S. master's degrees, so creating the current total of 85,000 available visas. Again, so it's remained at 85,000 since 2006. So the problem is the demand for that visa is significantly higher. It historically has been well more than the available visas. And so the problem, again, is that the cap is not, Congress doesn't consider the true demand in adjusting that number, or at least has not since 2006. And the other problem is that the demand has really ballooned as a result of the new online registration system that was rolled out in 2020 to make things, in some ways easier on employers. But what has happened is, as a result of the new online system, which is cheap and easy, is that it has invited some abuse. But just in terms of the demand, historically, the demand for these visas from, the 2013 to 2019 period was roughly 2 to 3 times. There were between 120,000, 200,000, 233,000 registrations in those years for those available 85,000 visas. And so depending on if you were a master's cap or a regular cap, your odds of selection were maybe 30%, 40%, 50%, but it was a somewhat predictable recruiting mechanism. As a result of 2020, the demand has really ballooned. And again, it's made it cheap and easy. And so employers have been registering individuals that maybe they're not necessarily planning on bringing over, but just to see who gets selected, knowing that everybody does not get selected. The bigger problem is that, it has invited more abuse. It has invited abuse that has always existed, but it's just made it cheap and easy to do. And so these placement agencies have popped up where they will, for a small fee of as little as $100, seek to find employers on behalf of these individuals, multiple employers to register for these individuals, with the understanding that only one of them may get selected. And so these prospective employees are actually the ones that are going to have to later find work through these companies. And so the demand it's inviting situations where individuals are registering where the demand may not necessarily really be there. We don't yet have the number for this year, but you can see how it's grown. In 2020, the demand was 275,000. In 2021, it was 308,000. In 2022, 483,000. And while we don't have the final number yet today, by anecdotally speaking to, seeing the numbers in our office, speaking to attorneys in other offices, we believe that the number is somewhere between 600 and 700,000 registrations, given the rate of selection, which is somewhere between 2 to 5% for the regular cap and 10 to 20% for the U.S. Masters cap. So most people were not selected because of this inflated demand. And so the H-1B visa, the problem is it is no longer a predictable way to retain talent and to attract talent to the United States.
Yes, and as many of you know, that with the registration process, you may have a status that says selected. So, Beata, for those that are selected, is there hope that they could actually get the H-1B later on this year?
Maybe.
So, I'm sorry, I meant submitted. If their status shows as submitted, could they still be selected later this year?
Right. We don't yet know. So it's too soon to tell, and it may still be weeks or months before we know if there will be another lottery. In 2020, there were 2 lotteries held. In 2021, there were 3, one in March, one in July, and one in December to disperse all of those visas. Last year, there was only one. So USCIS caught on and recognized that many employers who registered these individuals won't actually move forward with those registrations and those filings, because again, that doesn't necessarily reflect the true demand. And also there could be changes that occur, right? From registration to when you move forward with filing, there could be a layoff, the individual can find a different job offer, lots can happen, but they selected 124,000 selections last year for those 85,000 visas, knowing that, between 30 and 40,000 weren't going to actually file. And since they haven't yet announced those numbers yet, we don't know if they're done for this year or if there will be subsequent lotteries. But that is still a possibility as of today.
Okay, great. And for an individual wanting an H-1B visa or a company sponsoring someone for an H-1B, do they have to go through this cap or this lottery system?
So typically, yes, for private employers. The exception is for cap exempt employers. So, when Congress created the H-1B visa, they created a cap, and then they created a set of exceptions for employers that are not subject to the cap. They do not have to go through the lottery. And so these are institutions of higher education that are public or nonprofit, no private universities that are for-profit, nonprofit entities that are related to those universities. So typically like hospitals, for example, or clinics affiliated with the university, nonprofit research organizations, and governmental research organizations. Now, the research part here is that these institutions are primarily engaged in research. Not that research is a small component of their work, but it is the primary goal of their work. These types of employers are not subject to the lottery and can seek an H-1B visa for their employees at any time. Interestingly, one possibility for private employers is if they have an individual that is working for a CAP exempt employer, such as a university, they can concurrently work for the private employer on an H-1B visa. So for example, if you have an individual that is a physician or a professor at a CAP exempt institution working full-time or part-time at that CAP exempt employer, they can concurrently work for the private employer on an H-1B so long as those two relationships exist. If the individual quits or is terminated from their job with the university or the hospital, then they lose their ability to continue working for the private employer unless they've been selected in the lottery.
Okay. Well, we know that many of the people that are on this webinar today and are in a situation where they're seeking an H-1B visa are F1 students. So we'll go next into discussing what their options are.
Right. I think the vast majority of the employers who are seeking H-1B workers are working with F1 students. So we admit 1 million, on average, foreign students into the United States every single year. And the vast majority of these are studying STEM fields. That's a fact. And so how do we keep 1 million students post-graduation in the United States when we only have 85,000 visas? This is the hard part. Fortunately, there are some options to prolong your F1 status and work in the United States post-graduation. Again, most of the individuals on this call will probably be familiar with these, and we'll just touch on them really briefly. But the first is your initial OPT or optional practical training granted for a year. So after a student graduates, they can work in their field related to the degree for a year. If they graduated with a STEM degree and they work for an employer that is enrolled in E-Verify, they can further extend that OPT work authorization for an additional 2 years. So that's a total of 3 years of work authorization post-graduation. And ideally, the individual would have been registered in the lottery each of those years, increasing their odds of selection. But again, unfortunately, with the rates of selection this round, at this point, that is no longer the case. It historically was the case that you could probably get selected in the first, second, or third year. But this year, the vast majority of them were not. Mm-hmm. Beyond OPT, there is the option of utilize what's called CPT or Curricular Practical Training Work Authorization. Now, this is work authorization for students that are currently enrolled in a degree program. And so it requires attending school full time. And so what a lot of desperate students do is enroll in a subsequent degree program, either going from a bachelor's to a master's degree or enrolling in a subsequent master's degree for the purpose of working. Some institutions will authorize CPT work authorization on day one. They're referred to as day one CPT schools. They are by far not the norm. These are rare, but they do exist. And some institutions will require that the student enroll first in full-time studies for a quarter, a semester, or even a year before they're allowed to work full-time while also simultaneously pursuing studies full-time. And so that's one option. There are also humanitarian options for students. There is the ability to seek work authorization off campus due to severe economic hardship. So if there's some sort of medical emergency or personal emergency, or if the student loses their source of funding and needs to work in order to finish their degree, they can request work authorization due to severe economic hardship. And then there's also special student relief for students from certain countries. Immigration and Customs Enforcement publishes a list of the countries from which individuals are able to seek this special student relief work authorization. This does get updated, but currently includes Afghanistan, Burma, Cameroon, Ethiopia, Haiti, Hong Kong, Somalia, South Sudan and Sudan, Syria, Ukraine, Venezuela, and Yemen. And so individuals from those countries can seek work authorization through SSR.
Wonderful. What about individuals that have a spouse of non-immigrant status? Can they benefit from this?
Yeah, so in some cases, if the employee is married to another non-immigrant, a person in another temporary status, sometimes their dependent status will enable them to work in the United States. That is, again, not the norm. The vast majority of dependent visas do not permit the spouse to work. But the exceptions are if the spouse has their own H-1B, they've been selected in a lottery previously, and they've been sponsored by an employer for the green card and reached the I-140 approval stage of their own green card process, then the spouse on the H-4 visa can work in the United States. Similarly, spouses of E-1 and E-2 treaty workers, which we'll touch on in a little bit, these are individuals from certain countries who are here due to investment. Their spouses can work. Spouses of E3 Australian workers are allowed to work in the United States. Spouses of J1 cultural exchange workers are allowed to work in the United States. And spouses of L1 intracompany transferee workers are allowed to work in the United States. So, unfortunately, the vast majority of these, again, we're talking typically about students for the most part. They're usually young, they're usually not married. But for some, again, you can utilize the dependent status to receive work authorization.
Okay, great. And there are also certain visas for individuals that are from certain countries. So can you expand on country-specific visas for these individuals?
Yeah, the United States has treaties with certain countries. And so these treaty-based visas, some of them have their own quotas as well, although they have never been maxed out or utilized. And so the first, I'd say the most common treaty-based visa is the TN visa for Canadian and Mexican citizens. So again, it does require citizenship, not nationality, not residency, for example, or some other status, but citizenship in that country. It is limited to certain occupations. It's not as broad as the H-1B, which can effectively be used in any professional occupation. The TN has a specific list of occupations. Engineering positions do qualify, but certain business-related occupations, for example, typically don't. But that's one option. We also have a treaty with Australia, so citizens of Australia can seek an E3 visa, which is very similar to the H-1B and can be used in any professional occupation. We have a treaty with Chile and Singapore, and so citizens of those two countries can seek the H-1B1 visa. Again, interestingly, the H-1B1 does have a cap. It has never been utilized, and so if you find a lucky employee for one of these places, then that's a great resource. And then the E-1 and E-2 treaty visa. This requires that the business that is sponsoring the worker be owned primarily by citizens of the treaty country. And so we have treaties with only certain countries, not all countries. Notably, China and India do not have treaties. Again, the vast majority of the individuals we're talking about here are probably from China and India. And so we do not have a treaty with China and India, and the E2 is not an available option for them. But for certain other countries, if there is a treaty, and if the business itself is primarily owned by citizens of that country, then working on an E1 or E2 may be an option for the individual that is the direct investor, the manager, or an individual working in a specialty position, an essential worker for the business.
Yes, great. And just to add on to that, the individual cannot be working for the U.S.-owned company.
Correct.
But another option for those with extraordinary abilities is the O1 visa.
Yeah. The O1 visa, sometimes referred to as the Einstein visa, although you don't actually have to be Einstein, is for the best candidates who have reached the very top of their profession, whatever it may be. So the regulations require that the O1 visa is for individuals with extraordinary ability in science, education, business, athletics, arts, TV industry. But really it's any industry. I mean, we've done O1s for individuals from, food production to social media marketing to engineering to statistics. I mean, there is no exception.
HR.
HR, that's right. So any field, but again, it's limited to individuals who've really reached the very top of their field. And how do you prove that they're at the top of their field? The individual must have won a one-time major international award, an Emmy, a Nobel Prize, something like that, very rare, or have received at least 3 other criteria or meet 3 other criteria, such as having other major awards, not necessarily internationally recognized, perhaps it's a national award, having a very high pay in comparison to others in that field, having made some significant original contributions to that field. Maybe they've patented something. Maybe they've developed a new process to improve. Maybe they've made the company really, really profitable through improvement of systems, for example. They've maybe worked in a critical role for organizations with distinguished reputation. So they work at senior levels. Maybe they've published research articles, or they've judged the research of others, or judged others in another capacity. So there is a list of sort of other criteria. And if they can demonstrate through evidence that they really are at the very top of their profession, then this is a great visa because it does not have a quota. It can be sought at any time.
Great. And another option for individuals who are working for a company abroad with a U.S. affiliate or partner or subsidiary is the L1 visa.
Correct. The L1 visa is the Intracompany Transfer visa that allows multinational companies to transfer their talent from their foreign office to a U.S. office. And so at a minimum, there must always be at least 2 offices, one abroad, one in the United States. It does not matter whether the foreign office is the headquarters or the parent company and the U.S. office is a subsidiary or vice versa, so long as there is a legal affiliation between the entities. One of the core requirements is that the individual must have worked for the foreign office for at least 1 complete year before coming to the United States, 1 complete year during the last 3 years before coming to the United States. And they must be coming to the United States to work either as an executive, a manager, or in a specialized knowledge capacity, some specialized position, not sort of an entry-level position, but the individual has some sort of unique information about the company, about the products that they're selling. There's something unique about them. This is an interesting option that is often utilized by companies that have these students working for them and have offices offshore. We've seen a lot of companies send their employees, after trying for multiple years to get them into the lottery, once they've exhausted all of their options, they send their employees to their foreign offices for at least a year or longer, with the plan of either bringing them back in on an L1 after a year, or sponsoring them trying to sponsor them for H-1Bs and then bringing them back on an H-1B, or going maybe directly into the green card process, for example, and ultimately bringing them back here. One thing to note is that the individual's presence in the United States during that 1 year cannot be counted to satisfy that 1 year requirement. And so the 1 year clock has to be calculated very carefully. But this is a great option for multinational companies. Unfortunately, if you don't have offices offshore, this is not an option for you.
And individuals seeking to get an L visa can either be in a specialized knowledge position or a managerial or executive position. There's an L1A and an L1B based on what you do for the company. Beata, can you touch on training visas next?
Yeah, so training visas are not necessarily employment visas, although an individual can be paid. These options are for bringing someone into the United States to receive training that will advance their career abroad. The one that is the least known, I would say, is the H-3 training visa. What's really interesting is that this one does have a cap of 50 50 visas per year. Also has never been met. So very few people actually seek these out. But the essence of this visa is that the individual must come to the United States to receive training that is not available in their home country. So you have to first prove that that this training is simply not available and cannot be done remotely. Maybe there is equipment that they need to utilize in the training that is physically located in the United States. Or maybe there is a subject matter expert physically in the United States and the training must be done in person. So number one, again, can't be done in the home country. And number two, that it is going to advance their career back home. It's not really appropriate to use this as a mechanism of eventually switching the person to another visa. It's intended to bring them back home at the conclusion of the training for some period of time at least. Now this can be done the training can be up for up to 2 years. Similarly, there is a J1 trainee or intern visa. Now this one does not have a cap. The J1 program is a cultural exchange visa that allows individuals to come to the United States for a variety of exchange opportunities. You can come to the United States as an au pair. You can come to the United States to be a physician or researcher. But I think what's most relevant to individuals on this webinar is the trainee and intern visa. So an intern is a person who is either still in school abroad or has just recently graduated in the last year, who can come to the United States for an internship training for up to a year and then go home. A trainee visa is for an individual that is more advanced in their career. They've, for example, had at least 5 years of experience or a degree and 1 year of experience. And they can come to the United States to be a trainee in a US company for up to 18 months. Now, one thing to know about the J1, and this is true of all J1 categories, is that some J1s have to go home for 2 years before they can later seek an H-1B, for example, or a green card. It's referred to as the home residence requirement. And it depends on whether the individual is receiving government funding to come to participate in the program, or if they are a physician, or if they are from a certain country that's published on something called the skills list. And if they're from a certain country and working in a certain area, their country literally wants them to return. And so you have to evaluate that before deciding that you want to proceed with this visa, because it really does limit a person's options if they participate on the J1.
Absolutely. If none of these prior options are available, then can you touch on humanitarian options that may be a possibility? These
will probably never be ideal, although I'm just mentioning them because every once in a while this makes sense. So there are a variety of humanitarian statuses or quasi-statuses that allow individuals to work in the United States. The most common, employers are probably familiar with seeing individuals with temporary protected status, or TPS for short. Congress adjusts the countries that are eligible for TPS depending on the state of emergency in the country, but essentially it's a recognition that people from certain countries just can't go home. So for example, right now, Ukraine and Syria. And so if an individual is from one of these designated countries and registers by a particular date, they can seek work authorization through temporary protected status and may be able to extend it further, but only if Congress authorizes it. Another option is asylum. Now, asylum is incredibly difficult to establish, but if the circumstances make sense, if the person truly fears persecution in their home country on account of their race, religion, national origin, political opinion, or membership in a particular social group, they can receive work authorization while their asylum application is pending. Similarly, we have VAWA for victims of battery or extreme cruelty by a U.S. citizen or permanent resident family member. Deferred action for childhood arrivals, DACA. I think most of us are probably familiar with DACA. These are the dreamers who were brought to the United States as children. And then victims of human trafficking, the T visa, and the U visa for victims of other crimes where they are participating in an investigation or assisted in the investigation of that crime. Again, it's unlikely that these will be ideal because most of these are not deemed a status necessarily. So depending on the circumstances, I guess I would just say it may not be a best fit to pursue one of these unless it is absolutely the last resort.
Right, right. And if these humanitarian options are not the case, and neither are the temporary visas, the non-immigrant visas that we've discussed before are an option, then your last option may be to go ahead and start the green card process.
Yeah, so the green card process could be a webinar unto itself. And again, we're just going to briefly mention some options here, but we do have clients jumping directly into a green card sponsorship, given that the lottery is just so unreliable. If the individual happens to already be in a relationship with a U.S. citizen, marriage to a U.S. citizen does result in a green card if the person's eligible, and work authorization while you're waiting on it. And so, unfortunately, this situation has certainly fast forwarded many relationships. If also the individual is a dependent of a person who's got their own green card process. So again, we mentioned earlier that if the spouse has an H-1B or some other visa, they may be sponsored by an employer or a relative for their own green card process. And depending on where they are in that process, the dependent status can result in work authorization. There is also the diversity lottery. We have a lot of caps and quotas in immigration. We have a lottery where 50,000 green cards are distributed every single year randomly to individuals from certain countries. Again, notably, China and India are not on the list because they are countries where we have high immigration. And the purpose of the diversity lottery is to diversify the immigrant population and invite people from countries where we have low immigration. But very few people ever get selected. Millions of people, both in the United States and abroad, register for the diversity lottery every year, but it is something worth registering for. It has no fee. And then finally, there is the option of employment-based sponsorship. Johnny.
Yeah, right. So for employment-based green cards, which are utilized highly, there are multiple categories. There's EB1 through EB5. And it's a 3-step process to get a green card unless you are an EB1 or EB4 and 5. And EB1 allows individuals that have a national interest waiver or an extraordinary ability, kind of the standard that we talked before for the O1, to skip a couple of the steps and go straight to getting a green card. However, the majority of individuals qualify for an EB2 or an EB3, where an employer is sponsoring them for a permanent position once they get their green card. To emphasize, this process does take 2 to 3 years because it's a 3-step process where we start with the PERM, the labor certification step, and then there is the I-140, the immigrant visa petition, and then you end with the green card application. For individuals that are Indian and Chinese nationals, there could still be a gap in work authorization if, for example, you're on an OPT or a STEM OPT and you do not get any other underlying status, such as an H-1B or O1. In the meantime, because there is such a backlog of people that have applied for their green card, and there's only a certain amount of individuals that can get a green card in a year. There's a cap, a limitation per country. And so Indian and Chinese nationals are often left waiting 5, 10, 15 years before they get a green card. However, for those that are not Indian or Chinese nationals, they can often apply for the second and third step of the green card process, the I-140 and the adjustment of status concurrently. And when filing for the adjustment of status, you can also apply for an employment authorization document that would allow you to continue working while your green card application is pending. So For those of you that are currently in OPT and are thinking that, I still have a couple of years before my work authorization is going to expire because I plan on filing for STEM OPT extension, actually the time to start talking to your employer about this would be now, because it does take 2 to 3 years before you would see that employment authorization document in your hand.
Yeah, again, I just want to emphasize that the employment-based green card process for anyone who is not Indian and Chinese is a great option. Not necessarily skipping the H-1B entirely, but initiating it as quickly as possible with the goal of reaching a point where you can work on work authorization through the process with or without an H-1B.
And you can concurrently continue applying for the H-1B in the lottery while this process is going on.
Right. There is a question here from someone in the webinar about, there's a lack of teachers in the United States. Is there an option for those with teaching credentials? This is true of many occupations. We have shortages in nursing. We have shortages in many fields. And unfortunately, we don't have a visa specific to an occupation like teachers. But the green card process that Chandni just mentioned, that is recruitment based. It's a process in which the employer conducts a labor market test to prove to the government that there is a shortage. That's, I think, what makes sense in a case like this. Unfortunately, the process takes 2 to 3 years for someone that is not Chinese or Indian. But in essence, again, you're sponsoring someone because of that shortage. You're conducting a labor market test. You're demonstrating to the government that there is a shortage. You were unable to fill the position with a U.S. worker. Therefore, you wish to seek this other foreign worker for the position. Whether it's a teacher or somebody else, there is no limit to the types of occupations that can be sponsored for a green card. But unfortunately, you're going to be waiting, 2 to 3 years for those non-Indian and Chinese nationals before they can work for you, whether they're in the United States on some other temporary status or they're abroad waiting. It is not a fast process. And so you really have to have, most employers wouldn't initiate this unless they were desperate and truly in need. But that is an option. We're almost running out of time. I don't see any other questions. So I want to thank everybody who joined us, and again, invite anybody to contact us. The contact information is here. We can schedule calls and consultations both through our phone number, 312-427-6163, or through our website, www.mmhpc.com. And we do offer those free corporate consultations to employers seeking to sponsor someone or keep someone. So please reach out to us if you have any specific questions about anything we've discussed today or any of your employees. Thank you for your time.
Thank you.